Introduce our next speaker. I met her actually early on with my tenure with AARP. We met right away. She sent me an email, and it turns out years later we're working together on guardianship. So our next speaker is Valerie Del Grosso, and she's an elder law attorney practicing since 2008 in her hometown of Las Vegas. Her practice transitioned to elder law when a friend's father was diagnosed with Alzheimer's at a young age. She learned about new estate planning techniques to help his family avoid losing everything to nursing home costs. That practice has expanded into guardianship, Medicaid planning, and probate in the ensuing years. So please join me in welcoming Valerie Del Grosso.
Hello there, I am Valerie Del Grosso. I sent that email to Linda several years ago now because I wanted to ask, where is AARP on long-term care planning? And as you can see by an event like this, they are trying to be at the forefront and definitely are in providing this information. So there are kind of two things I want to talk about today. I know the schedule just says Medicaid Asset Protection Trust, but I think before we have that conversation, I want to put it in the context of the roles that a caregiver has and why taking action to get something like a Medicaid trust can be really a great way to make a disability plan that might not otherwise be that exciting to make. So in my practice, we run into clients usually in one of three stages. The first are the people who are planners. So this is a person like my mother who has the menu picked out for her own funeral already. And I can appreciate that though, because every detail is planned and I know exactly what her wishes are both during life and after she passes. The second group of people are caregivers, and excuse me, usually they're coming to us because they've hit some kind of roadblock and there's not really one great place to turn for very specific information on what they should do next. So a lot of times when they're coming to us in that situation, we're doing what we call crisis planning. And I would consider a guardianship one type of crisis planning. We're hearing a lot about that today. We're gonna talk about some alternatives to being in a crisis situation. The third group, especially here in Las Vegas, because we have a big retirement community, are family members from out of town who are trying to squeeze in time from their own life and take care of their own families to come across country and use what little vacation time they might have to quickly make decisions that they might not be super informed about. So the conversation that we have a lot of times is surprisingly not legal, but in fact about a lot of practical issues. And so for those of you who are caregivers, the things I might talk about here shortly are not going to come as a surprise to you, but a lot of people do end up being surprised that they're going to have these roles. And those are stewardship, they're the business role, advocacy role. These are on top of the nitty-gritty of day-to-day caring for somebody. And they could take a lot of time and they require a lot of information. So what a caregiver is doing in each of these roles is going to be, the difficulty of it is going to be either greatened or minimized based on the amount of planning that was done in advance. And so when people's wishes are not really documented, it can leave the caregiver open to a fight on a lot of unexpected fronts within the family, with the person they're caring for, and even with, for example, financial institutions that are not super well equipped at this point to handle the subtleties of what it takes to be a caregiver. There are, of course, organizations working to help these issues. Jim talked a lot about the fact that now every case is having an attorney appointed so we can minimize some of the abuses. The self-help center someone mentioned, it's a great resource so that people can handle these things on their own. But we're gonna look at the specifics of these roles and what you can do at each stage to get some planning in place. And for those of you who are caregiving for people who are still capable of making decisions, to encourage them to have conversations about these topics. Because as bad as it is to talk about our disabilities or even mortality, it's even worse to not talk about it because it puts a lot of strain on the caregiver. Stewardship. We consider this where people's preferences for care cross with resources, because the reality is most people who come through our office, they are insistent that they want to stay home. And I understand that there are a lot of cultural issues surrounding the desire to be cared for at home. But the reality is sometimes the need for care, it becomes too great, too soon, requiring care to come into the home that can be very expensive. So simply saying, I want to stay home, or having an understanding with the person you're caring for that they want to stay home for as long as possible, can really create some issues if we don't look at what the reality of staying home looks like. I'll give you an example of a client we had recently. She has since passed away, unfortunately, but she had a caregiver coming in, just a housekeeper, nothing medical. She was very sharp when we met her. We did a simple estate plan for her. And fast forward a year, her nephew is calling from New York saying, I'm hearing from the neighbors that the housekeeper is up to $6,000 a month, still no medical care happening. And what had happened was our client her relationship had developed with the housekeeper. She trusted her. She wanted to have her there. So now here's the nephew in this situation where it looks to his aunt like he's trying to interfere with what she wants. But the thing was, she was running out of money so quickly that this treasured relationship costing $6,000 a month was going to be the very thing that was going to cause her not to be able to stay at home, which is what her wishes were. So luckily, we were able to intervene somewhat and minimize that, and then unfortunately, again, she passed away soon after. But those are the situations that someone going about their daily life can have to encounter when the wishes aren't documented and things aren't monitored sooner. Stewardship also involves understanding what resources are available, and I know we speak to many families that they don't really speak about money. And so you have this problem of no desire to speak about mortality and disability, compounded by a relationship where there's not an openness about money. And so when the time comes to make arrangements, a lot of times the children are not really aware of what is even possible. And then they're confronting high costs of staying at home, for example. So it goes without saying that a caregiver has to navigate these increasing needs at home, because typically the needs do increase over time. And that becomes a central role of a caregiver to figure out what is out there. So just as a quick aside, Nevada, unlike states like California and New York, we really have sort of a flat structure of options that are available. There's home care, there are aides that can come in for non-medical plus medical care. These are typically all things that are private payment. There are some respite care vouchers that might be available for one day, once a year, possibly depending on budgeting. There are no real transportation options. Those are typically, the person has to be able to get out to the sidewalk to get on, for example, a city bus. So I say this because for those of you who might be out on the internet or out in the community talking to find out what is available, it's not always crystal clear. And then from there, of course, there are assisted living facilities, some of which have income limitations so that you can have a lower cost to live there. And then finally, we get into long-term care, which we're going to talk about here shortly, where depending on what assets and income you have and what medical needs you have, the state may be able to pay for that nursing home care that can cost $7,000, $9,000, $11,000, $12,000 every month, depending on the degree of care that's needed. So this is the information that the caregiver is, it's not common sense necessarily. So on top of all their caregiving duties, they're out there trying to figure out when is it time to have the conversation about moving to a facility? When is it time to go and get an aide that might be $20 an hour, 24 hours a day? Are the resources there? And just a word on long-term care insurance. For people who have long-term care insurance, I still encourage them always to do some planning on top of that, because the policies, we see a few issues in our office. Number one, during the financial downturn in 2008, 2009, a lot of insurance companies were making some bad bets on long-term care policies. And so some of these programs are not always quick to pay due to solvency issues. Some are better than others, but if you do have long-term care policies that you intend to rely on, I encourage you to take a look at the strength of your insurance company, because if you have time to make other arrangements or have some type of backstop in place, it's worth looking into that. So all of this care would be paid for out of pocket to the extent that it can't just be done by family members. So caregivers need to be aware of government benefits programs, and here in Nevada, the #1 program for long-term care is Medicaid. Medicare does not cover stays in skilled nursing facilities beyond 100 days, and that's only following some sort of acute health crisis. Usually we see it hospital to rehab facility and potentially an extended stay there. But after that, the family's on their own to either pay out of pocket until the money runs out, at which point the state will kick in, or if they have done some advanced planning, they may not have to spend all of the money, but would still be able to have the state kick in. And so that's where we'll talk about Medicaid asset protection trusts. And I touched already on the cultural and family issues. I understand readily in some families, the option to go into nursing care is a conversation that no one is willing to have. The topic, or the way that I broach it in my own family, and we see this a lot in our work with the Legal Aid Center in the guardianship cases, is that sometimes the hospital will make the decision for you, because unfortunately, inevitably, people will end up in the hospital for one thing or another. And the hospitals have a duty when they discharge a person to make sure that the discharge is safe. So an example with my own grandfather, he's 96, he's very hard-headed, he is sharp as a tack, but he cannot get his own socks on and off. He cannot do laundry, he's not cooking, he does not want to socialize at his assisted living. And he recently had a little scare, injured his shoulder, and they said, we need to evaluate the setting that you're going home to. We don't think you can go home to this situation. So that's a lot of times where people's plans to just be cared for at home can go sideways. That could be good or bad, because it might be an opportunity to have a difficult conversation that otherwise people don't want to have. Okay, so that's stewardship. It covers a lot. The second unexpected role is the business side of things. It's caring for somebody is much more than helping get the socks on and off and doing the laundry and medication management. The caregiver has to understand and advocate even, which we'll get to that in a second, about how capable is this person of making decisions anymore. So you heard this morning, powers of attorney can be an alternative to a guardianship proceeding. And you may be thinking, okay, can this person I'm thinking about really sign those anymore? And we know a few things about people in particular that have dementia or their cognitive issues, and that is sometimes at a different time of day they have more capacity and understanding than others. And so you want to advocate for that as much as possible. We also know that when it comes to powers of attorney, which there's going to be a presentation about that, the standard is lower than some other things. And so for people who understand who the family members are and what sorts of powers they're giving, they can probably take advantage of the power of attorney, which is a really powerful legal document. The guardianship issues, that's covered at length today. Understanding the estate planning. So I'm not really aware of a lot of organizations giving presentations on long-term care planning or Medicaid planning specifically. So for those of you who are here who are caregivers, this is information, take to your community of other people you know who are caregiving as well, because your traditional estate plan is really not going to help you plan for disabilities. The caregiver has to understand when and how to qualify for benefits without impoverishing the family or diminishing the standard of living, for example, of a healthy spouse who really isn't ready to go into assisted living or a nursing home. And then we see these all the time in our guardianship cases. Having those tough conversations about gun ownership and taking away the keys are also things that the caregiver has to be ready to face, whether they like it or not, a lot of times. So the third unexpected caregiver role is advocacy. And I think that awareness of the burdens and struggles and rewards of caregiving is getting a little bit more mainstream. But when you think about the percentage of Americans, particularly who They call them that sandwich between maybe kids that are just becoming adults and parents who are starting to get up in age. The awareness really doesn't match the number of those people who are spending even just 1 hour a week or more on caregiving activities. So it may come as a surprise. I was actually talking to my own dad about this presentation, and he said, well, even with 96-year-old grandfather, we're not really caregiving. And it's like, he's the one who's driving over there twice a day to change his socks, and in his own mind, he doesn't view that as a caregiving activity, but it really is. The thing about the lack of awareness, though, is it shows up even in the most unexpected of places. Everything from access, just for people with disabilities in wheelchairs, even though we have the ADA, to financial institutions that really should be equipped to understand that sometimes people are going to have a family member come in with the power of attorney. The big thing we see in our practice about this is people will sign that power of attorney years in advance, and then they will be in a situation where they can't speak for themselves. The family member will take the power of attorney to the bank, and the bank will say, oh, that's great, bring this person in and fill out our paperwork. It's like, well, the whole point of having this power of attorney and the whole reason I'm here with this document is because this person is not capable of coming here. So in our office, we're waiting for the right client who wants to sue a bank over that, but so far nobody is really interested in being the test case for that. So let me know, though. Okay, so do we have anyone here from the state? No, okay. Okay, so the thing with a caregiver, this one is so important, and we're going to talk about what the qualifications are for long-term care benefits. But we have clients that have gone in to apply for Medicaid for nursing home care, and I'll give you one specific example. Husband and wife, which means they can have up to $125,000 in assets plus their home. And the state will still kick in for nursing home expenses. This particular couple did not have a home, but they did have $30,000, and it was a lot of money to them, and it was their life savings. So mom needs to go into the nursing home, and Medicaid says, oh no, you have to spend that whole $30,000 down. Luckily, their son came to our office, and we were able to educate him and say that is an outright falsehood. They do not need to spend that money, and thank goodness he came and spoke to us, because he was able to step into that caregiver role and go and advocate, where dad, who yes is capable of living on his own, is not really capable of engaging in these conversations, pushing back on government officials. So this is where a caregiver being educated is just so incredibly important. And that's, of course, on top of understanding the healthcare regimens of the particular person they're caring for, and then trying to also live their own lives and take care of themselves. So the question is, where does the caregiver turn for guidance? We already talked about, the fact that information you can find out there is not really necessarily very specific, or it may not apply in your state. All of these things are very state specific. And the answer to that question is, first and foremost, looking to a written estate plan that includes disability planning. In our office and in the office of other elder law attorneys, we like to call it estate planning with lifetime benefits. And before I get into what the benefits are and how to get them and all of that, let's just talk very basically about what happens if, first of all, there is no written plan. Or I should say, okay, first we'll talk about this. I'm going out of order, sorry. Just what is an estate plan? Typically when we think of it, we think, what happens to my stuff when I die? And I just read a thing saying that Americans are not returning their online purchases, so we're all turning into hoarders. So we see and hear a lot about houses that look like this. Okay, so in other words, what do I get by having this unpleasant conversation with my elder law attorney? And first and foremost, you take the burden off of your family members to have to make a lot of the decisions that we just talked about and face those issues without understanding what you want. So unfortunately, it's usually the favorite child who ends up having to bear the burden of all of this decision making, so no good deed goes unpunished. But the other thing too is, in a world where we're living a lot longer, and where we do have more options for care, and where typically our children are in two-income households, so someone can't just stay home and quit, although we do see that a lot. The fact is, there's probably a substantial portion of us in this room who at some point are not going to be able to speak for ourselves, but are not really going to be in danger of passing away anytime soon. And I'm a control enthusiast myself, so I know that I have specific ideas about how I want to be treated at the point where I can't speak for myself. And disability is different also than many people think. Jim probably touched a lot on the continuum of capacity and when a person can make decisions versus when they maybe can make decisions and may even be adamant about them, but also don't really appreciate the consequences of their decisions. So all of that range is involved in a disability situation. Part of that is just having powers of attorney signed and avoiding the cost of guardianship, as well as people having to make decisions for you that either they're not the person you would have in mind, or it's a decision that you actually would not make. So the second benefit, though, of this disability planning is that when it's done far enough in advance, you can also be sure that you don't have to spend every cent you have to get long-term care should you need it. And the great benefit of that is that we see in the news that there's talk of Medicaid being cut. Obviously, the baby boomers, that generation, the need for long-term care is swelling. The benefits at some point are going to be lessened, and you want to empower your family with the money that you do have to be able to make up for shortfalls in care that may occur because of program changes, or even just be sure that a legacy that you worked a really long time for, that there's actually something left to give your family when you do pass away. And it's our position in our office that a lot of times the money is better off in the hands of family members to some extent than just paying full price for nursing care and then being left with only $35 a month to pay for the things that keep your lifestyle the way that you're used to it. And we'll talk about that $35 number in a minute. So the state of Nevada, like other states, does actually already have a plan for you, even if you don't have one in writing. We call this the No Plan Plan, and it really fits people who are, I'll say, a very traditional family. Husband, wife, 2 kids, everybody's friends. And if you're in a family where maybe someone's already gotten their fair share, or maybe there's somebody who, for whatever reason, you don't want to get something or to be involved in making decisions for you in a healthcare crisis, the state plan doesn't take that into account. And so that can cause a lot of strife among the people who have been in your life for a long time and who've been there all the way through. So the big downside also of the No Plan Plan is that when it does come time for decisions about care and or distribution of assets to be made, a judge will come in and fill the gaps. So even if the judge does a great job, someone, again, usually that favorite child, has to go to court and make it happen. In our probate practice, we see a lot of times, someone passes away and the kids are rushing to the house to get things, and everyone's being disorderly and distrustful with each other. And that even happens when we see people who are going into nursing facilities as well. So a step above that is a last will and testament. You've probably heard about that. You still have to go to court, and basically for every $100,000 in assets you have, including your home, it costs about $4,000 to probate. So it's an expense that really can be avoided, and if you're already getting the will, it makes sense to get a plan that's actually going to have some disability planning in it, because the will does not usually. All right, so the trust. Trusts are very flexible. It's essentially, during your life, a contract with yourself to handle your affairs in a certain way, and it's specific instructions to the person who's going to occupy that role, either when you can't speak for yourself or once you've passed on. It just so happens that Nevada is one of the best places in the whole world to create a trust because we have a lot of very wealthy people here who are housing a lot of money. And so we have great trust rules that have this unintended side effect of helping middle-income families who really stand to gain the most in a disability setting from having a Medicaid trust. So a basic trust keeps the court out of it, both during life and after you pass away. So that's one big headache that's reduced for your caregiver. But the other things that a trust can do are protect what you have from creditors. We all hear the personal injury, attorney commercials and all of that in this town. It's very litigious, but that's a benefit that a lot of people don't realize they could have to protect their assets using a trust. The other thing is qualifying for those government benefits that I talked about, and I'll get into the specifics of how that works. The other thing a trust can be really effective with is in a blended family situation. A lot of times we'll see people get remarried, they'll put the new spouse's name on the house, put the new spouse's name on a bank account, and then they die unexpectedly. And just based on the way they handled this, not realizing they were making estate planning choices when they were doing those things, they disinherit their first children. And try as we might in the law firm when those kids are sitting across the desk from me, it's really a hard thing to unwind the feeling that you were disinherited, even if it was unintentional. So if you have anything more than $2,000 and or you have a blended family, I really encourage you to look into a trust. For those of you that expect that you may need long-term care in the future, or if you have a family history of any kind of cognitive issues like dementia, Alzheimer's, Parkinson's, those types of things, I also really recommend that you look into the Medicaid Trust specifically. And what that can do for you is ensure that your wishes during life are both communicated in an organized way and respected. And I note that I was just talking to Jim and Riley over here about the $99 will. Probably everyone in here has run across an advertisement for that. And you could see already that in a caregiving situation, that $99, it's inexpensive in the moment, but it can cause a lot of costs down the road that are deferred, as well as a lot of extra decisions that have to be made. And this type of estate planning also can help you preserve that legacy. We can write down who we want to get all of that stuff, but if there's nothing left because we had to spend it all on catastrophic health expenses that may or may not have been expected, it's difficult to do things like leave money to grandkids to go to school, or even just pay for the expenses of a final illness or for funeral expenses, which can be expensive. Here is the catch, though, with a Medicaid trust as compared to any other trust. The state says, all right, when it comes time to qualify for nursing home benefits, we will pretend not to see what is inside this trust, so long as you put it in there more than 5 years ago. So a lot of what we're talking about today has to do with capacity, and that's obviously incredibly important. A person has to be able to make competent decisions about who they want to get this stuff and even to understand the process entirely. And that in and of itself is time sensitive, of course. But if you think that you will need long-term care benefits in the future, it is not ever too early to start looking at this type of estate planning to protect those assets and get them off the table, so that should you need care 5 years and 1 day or more from now, it's already taken care of. So when we talk about crisis planning in our office where somebody is getting ready to go into a nursing home and mom and dad have $150,000 in retirement accounts and different things, the state is going to say, go spend that $75,000 at $8,000, $9,000, $10,000, $12,000 a month, which doesn't last very long, and then we'll look at helping nursing home care. And by the way, we're not really worried what type of care the healthy spouse out in the community is going to need to maintain the household and have the status quo. So even for families who have less than that, like my clients I mentioned earlier who had $30,000 left, following the rules is made much easier when you plan in advance using this type of trust. Sometimes people will say, well, I hear that they won't look at my home, and that is true. But even in a crisis planning scenario where they need the care now, and they didn't do the estate plan 5 years ago, the state will say, okay, we'll let healthy spouse stay in the home, we won't count that. But after the spouse in the nursing home passes away, we're gonna attach a lien to that house. It's not all bad because Medicaid pays a lot less than $8,000 and $10,000 and $12,000 a month for nursing home care that we would private pay for. But that's still something that follows after the fact, and that can also cut into this financial legacy. That's kind of a very simple way of looking at it, but the takeaway here is if you've got capacity and you've got probably 5 years, you want to speak with an elder law attorney specifically about how you can use an estate plan that has this lifetime benefit of helping you qualify for these benefits sooner, rather than having to totally spend down and hope that the programs will always cover what you need because you don't have the resources left should they not. This image is taken from an elder law attorney in the Midwest who's very well established. I do not have his specific permission to use this, but it's just so good. And so my goal with this as I wrap up is to just show you certain things that come up at different stages in this elder care journey that would trigger you to say, you know what, it's time to take this step or start thinking about this or that. So this image, it's a little difficult to see probably from where you're sitting, but it starts with someone who has gone into retirement, they're healthy, they're energetic, they're traveling, they're doing things. And then it goes through a health scare maybe, but they go home, everything is fine. And then it gets to this point where they have that type of hospitalization I mentioned that it's not so certain they're gonna go home, and in fact they do end up either in an assisted living or in a rehab. And then it goes all the way through, nursing home care, and then the end of life. So based on this timeline, really everybody in this room, but especially people who are just entering retirement, use that extra free time to go and get those powers of attorney put in place. Anybody who's got capacity, pretty much any financial position, should take advantage of this, and there's a range of documents that you can get. If you have cognitive issues in your family that you know of, or even know that you've been diagnosed but you still have capacity, you should look into more than just the standard state form, because an elder law attorney can help put some extra provisions in there should it turn out that you need care before 5 years and you have a family member who has to do some more extensive advocacy for you. You want to empower them to do it. And I think I just covered this. Yes, the long-term care issues you want to be especially aware of as you get older and you're only now starting to do powers of attorney. 3 common mistakes that sort of happen between maybe that first health scare and going into an assisted living. Waiting too long for the powers of attorney. Adding someone else's name to an account. This one a lot of times will hit home for people. When you are dealing with a parent perhaps who's saying to you, I just don't want to be bothered with this stuff anymore. Handle my bill paying online. Or, you know, you're going to get everything anyways because you're the only child. Let's just go ahead and put your name on the house. These are those unintentional estate planning things that make total, perfect common sense, but that can actually impair your ability to get qualified for those government benefits because it could be considered gifting. And I'll talk specifically about the problems with gifting. And then the other mistake we see, and I understand, especially with the older age group, there's definitely a financial sensitivity to the cost of planning. And so there can be a tendency to go to a low-cost paralegal who's actually not licensed to practice law, or to go to Staples or Nevada Legal Forums and just pull things off the shelf. And I didn't put it in today's presentation, but there's a website where attorneys locally will talk to each other about different issues. And probably 6 months ago, someone posted and said, hey, what's everybody here doing for estate planning? Should we just go to LegalZoom? You know, we're lawyers, we can handle it. Or should we just go to someone who does it on the side? And the very first comment was, I love for people to go to LegalZoom. It's paying for my kids to go to college because there are so many unintended consequences. And so the attorney said, seriously, there comes a time when you really need to just do it the right way. And so if you are thinking there's a possibility of long-term care in the future, any kind of cognitive issues, this is not the time for an off-the-shelf kind of solution, because a simple mistake can cost you $8,000, $10,000, $12,000 a month for as long as the money isn't protected, but the care is needed. And you know, I want to say also here, we're talking about these numbers, and it may seem like a rich person's problem, or trust may seem like a thing that only rich people need. I mentioned this is an area where middle-income families stand to gain the most, because families that have $1 million or more, spending $8,000 a month for care for 2 or 3 or 4 years, there's still going to be a substantial amount of money left. But for a family that maybe has $50,000, that money would have a very significant impact, and it would all have to go away. And the biggest risk is actually seniors who are widowed, because I mentioned a married couple can have $125,000 plus a house, but a single person can only have $2,000. Well, yes, but there's only going to be $35 a month to pay the expenses of the house, because all of your income minus $35 will go to your nursing facility and the state will kick in the rest. So, I'm getting short on time, but I want to touch on 2 quick things. The gifting. I mentioned that the state will say, okay, if you put your stuff in a trust 5 years ago, we'll not see it when we go and look at whether you qualify for benefits. The other thing the state is going to look for in that 5-year period is money or things that you gave away for less than fair market value. For every $8,000 approximately that was given away, you get a penalty of 1 month. So let's say you gave away $40,000 to your kids because a well-meaning CPA said, hey, it's the end of the year, don't forget you could give a $15,000 gift tax-free. But they fail to mention you could actually give away $11.2 million before there's ever a gift tax. And so most people should not really be worried about a gift tax. We should be worried about a long-term care penalty. So giving that money away, now you go and you try and qualify for benefits, great. You have the medical need, you're out of money, so you qualify financially. And the state says, but you gave away that $40,000, so you've got to pay out of pocket for the nursing home for 5 months. Well, where is the money to do that? Probably the people you gifted it to are not, number one, don't want to give it back, if number two, they even still have it. So gifting is one of those things that's also unintentional estate planning that you've really got to be careful about if there's going to be a need for long-term care. And so last, the punchline is, well, what does it actually take to qualify for Medicaid, and how can I do it? For a single person, $2,000 in, let's say, a savings account, plus you can have income of about $2,200 a month. All of that will go to the nursing facility, minus $35 for haircuts and things like that. For a married couple, you can have $125,000 plus a house, but that's a little misleading because nursing home spouse gets $2,000, healthy spouse gets up to $123,000. But it can only be half of what the couple has completely. So for the healthy spouse to get 123, you actually have to have 246, and then 124 of that would have to be spent down by the spouse that's going into the nursing facility. This is another reason why, if you have that kind of money, you really want to make sure you have a Medicaid trust, so the money can be in there for 5 or more years, and the state will just pretend not to see that money. I think I mentioned earlier, Nevada, technically we have what is called home-based waiver care, but I've never met anyone who actually was impoverished long enough and also lived long enough to get to the top of the list. So for those of you who are looking potentially at assisted livings or in-home care, if you're seeking state benefits and not finding it, that's why. So to recap, the role of a caregiver is completely complex. I see a lot of sad faces out there, which I'm sorry about. But the takeaway is get your powers of attorney. If you're not indigent and you're putting names on accounts and you're putting names on houses, it's time to go talk to an elder law attorney. And if you expect that there's going to be a long-term care need, you want to make sure specifically you're talking to someone who can educate you about a Medicaid Asset Protection Trust. If you have an estate plan already that involves a living trust or what we call a revocable trust, that's not going to do the job. That'll avoid probate, but that's not going to help you qualify for benefits. So the estate plan, though, once it's in place, you can set it and forget it, and you can help preserve that financial legacy so there's actually something left to share with your family, and also to help maintain a lifestyle that you're accustomed to that I'm sure costs more than $35 a month. Yep.
Okay, I'm Gary LeDuc. On the gifting, how far do they look back?
5 years from the application date.
Okay. Is there a difference in quality of the nursing home that the state pays for versus most private care ones?
That's actually a great question, and technically, Medicaid is just a source of payment, and so the nursing facilities, there are federal regulations that say they can't discriminate against you because you're not private pay in your Medicaid. Unfortunately, we see aggressiveness, and this is another area where a lot of kids, especially out of state, will come to us and say, why are they threatening this, that, or the other? I mean, they've got to give tons of notice to move you, tons of notice if they're going to kick you out for non-payment. You do not need to pay them while the Medicaid application is pending, which can be 90 to 120 days. But of course, there's a profit motive involved, and these are people who are just doing their jobs. But you've got to really know your rights. But technically, no, there should be no disparity in care between private pay and Medicaid. You may share a room, but not always. We have clients that it's $12,000 a month at a place down the street from our office, and they have private rooms, and it's paid for by Medicaid. It's kind of the luck of the draw.
Thank you for your information. Now, you touched upon something that made me think. You said $2,200 income for a single person. Let's say that's Social Security. What if their Social Security is 23 or 24? What happens?
Oh, that's
there?
a great question. So here's one of the other reasons why Nevada is, we're thankful to the billionaires who hide money here. You can do in 2 steps in Nevada what you can't do in one in another state. We can use income funneling trusts. So it's a trust that would only ever be set up in that exact situation you brought up. She said, what if your income's $2,300 a month? You're just slightly over. Nevada doesn't disqualify you. They just say, okay, have Social Security, pay that money into this income trust. It goes right to the facility just in the same way, and you get to keep your $35. But if you don't have capacity at that time to sign that trust, this is where having that really robust power of attorney from an elder law attorney make sure that you have someone who can sign that trust for you. So that's where, you know, it's tempting to pay $50 for a power of attorney, but it's going to cost you $8,000 a month later if they can't get you qualified because you're $100 over in income. So it's all part of kind of a holistic plan. Thank you.